Yeah.
We on the record in cause number 328008, State of Texas versus Brendan Ryan Holland. Mr. Holland, would you please come forward? Your full name, Brendan Ryan Holland.
Yes, sir.
How you doing, Mr. Holland?
Yeah, how are you?
I'm doing fine. Mr. Holland, you are here represented by attorney Ornella DeSeta. Ms. DeSeta, how are you doing?
I'm doing good, Judge. How are you?
I'm doing fine. Uh, Ms. DeSeta, Mr. Holland's case is on the court's announcement docket. You have an announcement you'd like to make for the court?
Yes, Judge. The state has extended an offer. I'd like to be able to discuss this offer with my client and with Ms. Musgrove as well.
Okay, how much time do you need?
30 to 45 days.
Okay. Okay, it's gonna be reset till May 5th of 2021. And now, Mr. Holland is charged with a DWI second, and I don't think he was given any bond conditions. Mr. Setter, would you please hand this to your client? I will go over this with him. Mr. Holland, the document that has been handed to you is titled Standard Bond Conditions and County Court at Law Number 2. Do you see that document? Did you see that document?
Yes, sir.
Okay, I will go over this document with you. And it reads, following the arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, subsection A2 and subsection C2. Do you understand that condition?
Sure.
And condition 3 is that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, Your Honor.
Condition number 4, this applies to you because this is a DWI second, which is a subsequent offense under section 49.04 through 4906 of the Texas Penal Code. And condition 4 reads, a defendant who has been arrested or accused of any subsequent offense listed under section 49.04 or 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after arrest. Obviously, this is beyond the 10th day after arrest, so the court is going to give you 10 days to get this device installed. So you'll have until March 20th, and your attorney, you can provide the proof of your attorney can submit it to the court.
Yes, Judge.
Is that correct, Ms. Redmond?
Yes.
Okay. Now, your case is going to be reset until May 5th. You get a copy of your reset. And once you get a copy of your reset, you'll be free to go and you have a blessed day. And Ms. DeSeta, you'll be excused as well and you have a blessed day.
Thank you, Judge. Can we keep this copy or?
That's his copy, yes.
Okay.
Are we ready on
Johnson.
Johnson? Okay. We're on the record in cause number 325036. The state of Texas versus Galen T. Johnson. Mr. Johnson, would you come forward?
Good morning.
Good morning. Okay. We're on the record in cause number 325036. State of Texas versus Galen T. Johnson. Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay. Mr. Johnson, how are you doing?
I'm fine.
That's good. Mr. Johnson, the information in this case alleges that on or about February 24th of 2019, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of marijuana. Mr. Johnson, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Johnson, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you're guilty?
Yes, sir.
Mr. Johnson, I have before me what has been marked as State's Exhibit Number 1 as titled the misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, Mr. Johnson, are these your initials?
Yes, sir.
And on page 3 of this document, Mr. Johnson, there's a signature above the line that's titled defendant.
Yes, sir.
Is that your signature?
Yes, sir.
And on the next document, Mr. Johnson, which is the trial court certification of defendant's right of appeal, Mr. Johnson, do you recognize this document? And is this your signature above, the line that says defendant? There's one box that's checked at the top of this document. That box states that this is a plea bargain case and you have no right of appeal. Do you understand that? I have another document here. This document is titled the discovery certification. Do you recognize this document? Is that your signature on this document? Now, prior to signing and initialing these documents, did your attorney, Mr. Smith, go over these documents with you? And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge?
No, my address.
Okay. It's no longer Oakland. It's not your address is no longer on East Lavaca. Okay. Let me get y'all to correct that. It's down here. Is the zip code the same? Okay, good, good. Okay. All right. Now, Mr. Johnson, as I said, prior to signing and initialing these documents, the documents that you acknowledge, did the attorney go over these documents with you? And did you read and understand everything in these documents? Kind of where his signature is, was erased. Right here? Right here?
Your Honor. On the tablet, I can't really hear you all, so I don't know if you all are discussing this, but Mr. Smith, if it has 90/6, the 90 should be deleted.
Oh, you're talking about on the plea form?
Right.
6 months deferred offer.
Right. So I can't remember whether or not it had 90 anywhere on there, but if it is, it needs to be deleted.
On the first page and see what the plea form says.
It just says 6 months deferred.
Okay. Just making sure the 90 isn't on there.
Okay. All right. Okay. Okay, now, Mr. Yellen, Johnson, you acknowledge that my signature. You acknowledge that these is your these are your signatures and initials on these documents, and your attorney went over these documents with you. And is everything in these documents true and correct to the best of your knowledge? State, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
Okay, no objection. State's Exhibit number 1 will be admitted. Mr. Smith, you advised in counsel, Mr. Johnson. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Johnson, your attorney, Mr. Smith, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Johnson, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. Hey, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The state is offering 6 months deferred probation, a $300 fine plus court cost, and 30 hours of community service.
Mr. Johnson, the state is offering that you serve 6 months of deferred adjudicated probation. During that 6 months deferred adjudicated probationary period, you'll be required to pay a fine of $300 plus court costs of $437, which comes to a total of $737. You'll also be required to reimburse the crime lab in the amount of $100. You'll also be required to pay a probation fee of $60 per month. And you will also be required to pay a urinalysis fee of $15 per month. Your total monthly installments will come to a total amount of $225 per month. Mr. Johnson, would you be able to make the $225 per month payment? Okay. Mr. Johnson, you will also be required to perform 30 hours of community service, as well as adhere to the other standard terms and conditions of your probation. Mr. Johnson, do you understand the state's offer? And do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Okay, Mr. Johnson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Johnson, if you successfully complete the probationary period, this case will be dismissed. It would not appear on your record as a conviction, and you may qualify for a non-disclosure. You can talk to an attorney about that, and they are quite competent in these matters. And Mr. Johnson, please, you're going to stand on the X. You're going to follow the directions of our court clerk, and once you finish it here, she'll tell you what you need to do, and you'll be excused, and you have a blessed day.